Attorney for over 15 years, I bring to you the new Legal Hour, where you will hear from top attorneys and judges in areas such as family law, personal injury, child support and custody, trademarks, probate, and so much more. Join us every Tuesday at 12 noon on Facebook Live or YouTube Live to get the answers to general legal questions that you may have. And don't forget to subscribe to our new legal YouTube channel at Attorney Tamika Johnson. And for more information about our firm services, visit johnsonlawpractice.com today.
Hey everyone, welcome to the Legal Hour. It is 12 o'clock sharp, just about. I am a punctual person, so thank you all for coming on for our premiere live. I'm so excited about this show, our guest, and the upcoming episodes that we're having. So let me just briefly introduce myself. If you don't know me, my name is Tamika Johnson. I have been an attorney in Georgia for a little over 15 years, primarily in the area of estate planning and some other things in real estate, closings, and refinances for a good part of about 15 years. So this topic that we are talking about, basic estate planning and probate, is near and dear to my heart and also to our next guest. So when I announced that I was doing the Legal Hour show and I was asking people, what is it that you would like to hear about? What would you like to talk about from the legal spectrum? Because so many people always ask me, and I'm sure in our guests as well, they come to us like, hey, do you know how to do this in this certain legal area? Do you know someone who does this? And we don't do it all. We probably do just like a couple areas here and there, but I thought, what better way to give people information, legal information, than to have guests on the show. So I'm super excited to launch this live series every Tuesday at 12 p.m. This is your legal lunch and learn. We're going to make it an hour. I know everyone is working. So yes, I'm excited. I am running on about 4 hours of sleep. I got caught up yesterday in the revenge travel arena, and I was in Pittsburgh, but we didn't get home until about 3 o'clock this morning. So I am on fumes right now, but I'm still super excited to be here. So I always like to give numbers. I'm going to do this before I bring on our guests in this area. So basically, under 50% Americans have a will or trust. That means the majority of Americans do not have a will or trust. And so that's something that we're going to address. Some people just don't know where to start, how to start. They don't know if they have enough assets to do so, what circumstances require will or trust. And we're going to talk about those things. Just demographic wise, 55% of white Americans have a will. And that's going to be versus 28% of non-white Americans who have a will. So we definitely want to get those numbers up because a lot of us, we just lose property. We lose things, homes and assets that maybe we don't know about, didn't know about, because we have not properly planned. So with that, I am going to bring on our guest. Attorney Jammie Smith Taire, and I'm super excited to have her. She does so many things, and I'm just glad I'm able to get her on here today. So, brief background: Jammie, she is an attorney out in Georgia as well. So she is a part-time magistrate judge in Gwinnett County. If you're familiar with the area, we have people tuning in from all over the country. She is also the chief judge in the city of Snellville, and she has her own practice. So she does a plethora of things for over 20 years, super knowledgeable. And I know estate planning is one of those areas that she definitely has a passion to talk about and just kind of spread the information knowledge, just like I want to as well. So, and I have to, again, I have to say this, I have to apologize in advance because we did get home about 3 o'clock this morning. I have a 2-year-old, 4-year-old, and I called myself trying to get them up to go to daycare at 7 o'clock this morning. They would not budge. And the last time I checked, they were asleep with their father who was asleep. So you may hear some pitter patter. If that's the case, I apologize. Unexpected things happen, right? And so
well, hello. Thank you so much, Tamika, for having me here. I want to say you look fabulous. You
Thank
look
you.
especially fabulous for somebody who's operating on 3 hours of sleep.
Yeah. Thank you. I appreciate that. So yeah, like I said, it's unexpected, but you know what else is unexpected? Sickness is unexpected. Disability is unexpected. The impact that caring for a loved one, an elderly person, a senior, a parent, that is unexpected. The responsibility of caring for a special needs child, that's unexpected. And though we all know that we're going to leave this earth at some point, it's not unexpected. We just don't know when it's going to happen. And it is so important to prepare for those times, right? So we're going to start this conversation based off of something that happened about a month or so ago. And I know Jammie and I both kind of talked about it in some groups that we're both in. So I want to start off with that to kind of segue into our discussion. And it's about Chadwick Boseman.
I knew that was what you were going to say.
Yeah. And because I heard people, they asked me about it. They commented about it. They want to know more about it because they just don't know. You wrote a brief blog about it on your website, but basically, as you know, Chadwick Boseman died, and we heard, in the news that his wife basically split his estate that we know of in half and gave half to his parents, and she kept half. So there was a discussion. So Jammie, I want you to start off and just give your take on the Chadwick Boseman situation in the will and kind of what happened. I kind of came to my own resolve as to what happened, but I want to talk to you about it. And basically, we're going to start that as the conversation of the importance of having the will and trust, and the reason why they were probably in probate court in the first place.
Okay. Thank you so much. Again, thank you for having me on. And today I actually got a call from a client and they were talking about the Chadwick Boseman thing as well. So of course we all miss him. Sorry to see it happen. For his family, I'm not sure how unexpected it was, but for us as fans, it definitely hit home, and we were all just so sorry to hear that happened. I think that we were also surprised to find out that he didn't have a will, but not so surprising because we are now finding out that many celebrities don't have even a basic will. We won't even get into other things like trust and things of that nature, but not even a basic will or a power of attorney or an advance directive. And so I think that even though we are starting to hear that more and more, it's still surprising when we find out people of such means don't have these basic tools around them. These basic tools, which also means they might not have the proper people around them as well, helping guide them along this journey. Because whether you're Chadwick Boseman or me or anybody else, you should probably at least have a will in place. And that's just to help avoid your family having to go through so much additional trauma and drama after you pass. So the Chadwick Boseman thing, and what are my thoughts about that? Well, like I just said, I wasn't really surprised by it because I think that so many celebrities now don't have estate planning tools in place. And I think it's because we're still afraid to talk about death, even though we know two things are guaranteed in life. What are they, Tamika?
Taxes and death.
That's what it is. We all know it. We all know taxes and death are guaranteed in this life, but yet we still don't prepare for it. And that's unfortunately what happened with that Chadwick Boseman situation. Luckily, it sounds like the family was able to come to some resolve. I don't know what the laws are in that state, but I know in Georgia, if they wouldn't have come to resolve what it would have been. So in Georgia, had he passed without a will, and no children, then everything would just go to the spouse. It's pretty point blank. The parents don't have any dog in that fight. So it would have just gone to the spouse. So I'm not sure exactly what happened in that situation. I just read what everybody else read. They were able to come to a settlement, but I do know that in Georgia, what would happen. What we see most often, and I'm sure you can echo this, Tamika, with probate, because my office handles a great deal of probate. What we see most often happen is a fight when there's a blended family. So that's when you have a spouse and two adult children or some adult children. Because in Georgia, if you pass without a will, then everything goes to your spouse and your adult children equally, with your spouse taking no less than a third. And that's quite shocking, usually, to the spouse. Because you can have a situation where me and my man have been together for 20 years, and suddenly his children are telling me I got to leave my house. And that's usually not what we want to see happen. So that's why it's important to have a will. And I think that had Chadwick Boseman had, at least, like I said, a will, then what we saw happen probably wouldn't have happened.
Right. So let's kind of segue.
Government part of it. I'm sorry. I still don't quite get how they got that much money, because that wouldn't happen in Georgia. So I still don't quite get that part.
Yeah. And I guess, it really comes down to, if people decide anyone can contest it, right? Mm-hmm. So whether they're going to get something or not, but it still costs you to defend it or contest it. So maybe just to make it kind of go away, or, save some money, let me just go ahead and give the parents some. My take on it, I don't know. I don't say this is authority. In my mind, that there was a trust somewhere, but perhaps there was a minimal amount of assets, because it was like $3 million, which to me doesn't seem like a lot based on what he has done in his career.
No.
So I'm thinking that there was a trust, but there were these assets that weren't covered by the trust, which can happen. You can overlook some things, and these are the things that were not covered. So it's still important, even if you have a trust, to have a will as well, just to, account for things maybe that, you weren't aware of, you forgot about, or new assets that kind of came in. And so that can be handled as well. In my mind, that's what happened.
Well, I understand, but if that were the case, then that means somebody is guilty of some serious malpractice, because, anytime we do a trust, we also do what's called a pour over will. I haven't done a trust without doing a will. So if he had a trust, there should have been a will. They sort of go together. You might have a will without a trust, but typically not a trust without a will. That's the whole purpose of the pour over will is for what you just said, just in case we don't get around to funding or putting things in that bucket, then we have that will as a backup. So I would be surprised, I don't know, if he had a trust, but there would be a serious issue if we had a trust without a will.
Yeah. I mean, I agree with that. Everything that I do, it would have a trust would have a will and or pour over will. But just in my mind, I cannot wrap my head around it unless that happens. But we don't know.
We have what was it that Aretha Franklin did? Was it she the one with the handwritten and it was on the sofa or something like that? So I think weirder things have happened.
Yeah. So again, let this be the segue into just talking about the difference between a will and a trust. Some people don't know the difference. And again, there are different types of trusts, but just basically explain to everyone the difference between a will and a trust.
Okay. So a will is the document that says, in the event that something happens to you, where you want your things to go. And it becomes effective at your death. So you could go to someone and you say, okay, Jammie, here's my stuff, and this is how I want my things to go. I want this to go to my spouse. I want this to go to my kids. And we would put that in writing. And in Georgia, we make sure it's properly signed and witnessed. And that's the will. A trust is similar, except that it avoids probate. And that's typically why people want a trust. So in the trust, you also do the same thing. You outline exactly what you want to see happen to your assets. But a trust in particular, I'm going to concentrate today, this conversation for purposes of ease of conversation, on a revocable trust. So in that revocable trust, you say it becomes effective. You can say it becomes effective now, and you would be the trustee over that trust. So a will becomes effective at your death, whereas a trust becomes effective immediately. And sometimes people think of the trust as protecting them when they die, but it doesn't just protect you when you die. Unlike a will, it also protects you in the event of incapacity, because at the time you become incapacitated, that trust can also take effect. So that is one of the differences between a will and a trust. The trust is effective immediately. 2, the trust will avoid probate. 3, and this is another type of difference, in a will, you can outline who you want to appoint as guardian over your children. You cannot do that in a trust. That's another reason why it's important to have both documents, because if you have minor children and you need to appoint a guardian, that is not something that can be accomplished through a trust. It can only be accomplished through your, I need to stop doing other things. It can only be everything's popping up on the screen. It can only be accomplished through your will. So that is another difference between a will and a trust. Now with the trust, oh, go ahead.
No, go ahead.
Okay, so now with the trust, I like to describe a trust to people because that's also some confusion. They don't quite understand the trust, even though I just said it's similar to the will. With the trust, you have to put stuff in the trust for it to matter. So in my practice, which handles probate, we have people coming to me quite often with these trusts that were never funded. And by funded, we mean putting things in it. I like to describe a trust as a bucket. So you have this empty bucket. That's what the lawyer gives you. We create these, I call it a bunch of papers. That's what I always tell people it is. It's a bunch of papers. So you have this bunch of papers, but it doesn't mean anything until you create the bucket and put things in the bucket. So for example, you come to me, I give you these papers, I give you an empty bucket. Now we need to put things in that empty bucket. For example, we need to put your house in the bucket. Now we've funded the trust because things are flowing into that trust. That's not something you can do with a will. You don't put things in the will in that same sense. There's no bucket to put things in a will. But in a trust, you're putting things in the bucket. If you never put anything in that bucket, then it's empty and you basically have just a bunch of papers. That's what Tamika, is it okay if I refer to you as Tamika?
Sure.
Okay, that's what Tamika was referring to when she talked about Chadwick Boseman, and maybe there were things that weren't in the trust. She's saying, well, maybe he did put some things in the bucket, but some things got left out of the bucket, and that's the reason why he had to go through probate. So if you don't put anything in the bucket, you're definitely going to have to go through probate.
Right. And just for a kind of clarification, that means like your bank accounts need to be in the name of the trust if you want certain accounts to be in the trust. Same thing with property. If you have a home, it has to be titled in the name of the trust in order for it to actually be in the trust. And I think that's a lot of times when people are like, oh, okay, well, I have the papers, so I'm good. But there is the step on the individual who is creating the trust to put the assets in the trust as well. So there's a little bit of work on your end to do that.
That's correct. And you don't have to put everything in the trust. So there might be accounts that you don't want to go into the trust. Many of my clients don't want necessarily their bank accounts to go into the trust, even though it doesn't change ownership in any way. It just makes the trust the owner and you're the owner of the trustee. You're the trustee. So it doesn't change anything. There's no new tax ID number or anything for the trust. But just in case you don't want that bank account in the trust, that's okay. You don't have to put all of your assets in the trust, but you should put some of your assets in the trust. And since you brought up bank accounts, I will say that typically for bank accounts, you can also put what's called a payable on death or a transfer on death on those accounts if you don't put them in the trust, even if you do. But if you don't put them in the trust, to avoid probate, you can do a payable on death or transfer on death. Different banks call them different things. And that way, at your death, that asset passes to whomever you've designated it to pass to.
Right. And that's really super, super simple. It's just going into your bank and just filling out that form. So it's there already. So again, we're coming out of the pandemic. Hopefully we're not going back into it. But I was reading that the number has increased. 50% of young adults now have an estate plan now versus pre-pandemic, meaning young adults from between the ages of 18 and 34. 50% of those individuals have wills now or an estate plan because of the pandemic, which is great and amazing. Numbers are still down, but that's, great. But can you address when a person should get a will? Who should have it, at what age, and their situation?
Well, that's really surprising to hear. I'm glad to hear that. Most of my clients, quite frankly, are older adults, and even as they call in, they're usually much older than that demographic. So they're probably going on what's that website that should not be named? They're probably going online or something. I don't know. But that's a great question. I don't think that there is a magic number as to when you should get a will. Whenever you get stuff that you want to protect and you want to decide where it goes, that's when you should get a will. So if you move out of your house, or even if you're living at home with your mom and you have your stuff, your Xbox, or you have other things that you think are important and you want to decide where those things go, then that's when you should get a will. Because otherwise you're working for all these things. And when you pass, then the government gets to decide where your things go. And if you want to be in charge, if you want to be the controller of that conversation, then you need to go ahead and do some proper estate planning. But on top of just a will, there are other documents. Even if we don't convince you during this call, or somebody else hasn't convinced you that you need to do a will, there are 2 other documents that you probably definitely need to make sure that you have in place. And I'm sure we're going to get to it, but that will also be an advance directive and a power of attorney. So a will, typically whenever you've decided that you've acquired some asset, not just a house, that's why it's named the Xbox, anything that you have that you think you want to decide where it goes, that's when you need to get a will. But you might also want to go ahead and consider immediately anybody over the age of 18, I would say, should have an advance directive and a power of attorney. And the reason why I say that is because, at 18, they're going to go to your parents. But after that age, then your parents, they have to go through court to even get guardianship over you. So at 18, you should definitely at least have in place an advance directive and a power of attorney. An advance directive is the document that says that in the event you're incapacitated and unable to make medical decisions for yourself, who you want to make those decisions for you. And then the power of attorney is the document over your finances. And you can put terms in there to say when that will become effective.
Right. And I like to use the example of, when our kids go to college, even at 18, we can, even if we're paying for it, we don't have access to their grades. Right? We don't have access to anything, even if we're paying, right in the check. And so, if something were to happen, there are additional steps that even as parents in certain situations have to take legally, go to probate court, just to get access to certain things, or just to be able to speak or make certain decisions, even if your child is 18 or in college and you're still supporting them. And so, have the conversation with your kids as well. Once they're turning 18, if you're an adult, you're going to college, or even if you're not going to college, these are some of the things you should have. And, and make sure you have those things as well.
I didn't even know that my nephew just went off to college, and I was asking my sister about his grades, and she told me that. I said, what? You don't have access to his grades? She's like, no. I mean, she has to rely on him to get that information. That was shocking to me.
Yeah. Even for me to even speak to one of my daughter's like academic counselors or something like that, like she had to give me permission. So, even though I'm writing this check and, making these payments, it's not automatic. So those things need to be put in place.
And I think we overlook that we forget, especially about the advance directive and even the power of attorney. We forget that those things also need to be put in place because at 18, all bets are off. We no longer have that control. So the will, I give you a little leeway on that, but the advance directive and POA are things that need to be put in place immediately.
Right. So again, let's talk about why it's so important to have a will or trust, or will specifically in a situation if you have minor children. So I know we like to think we have minor children that we're kind of young. We have a lot of life. I have a 2 and 4-year-old, but I'm not that young. I'm good in my 40s. So, but why it's so important? I'm 45. I have, again, 2-year-old, 4-year-old. My husband is 52. Like, we're not young bucks. And so, when we revised our estate plans last year, I had to incorporate my youngest son. But, let's talk about a little bit why it's so important to have a will for minor children. I think people overlook that. Even if you don't have a lot of assets, your kids are assets. I'd like to believe that.
True. They are assets, and you want to get to say what happens in the event something happens to you and your spouse. And 45 isn't old to me, Tamika, but this also goes to our conversation about it doesn't matter how old you are. If you have children, then you definitely need to have a will in place as well, because then you get to appoint a guardian. And the guardian is who you're asking the court to basically give your children to in the event something happens to you and your spouse. So if you're 21 and you have a child, then you want to have a will in place because you want to say what happens to your child in the event something happens to you and your spouse. Now, what we get a lot, and I'm sure you get this a lot, are single parents.
Yeah.
So what happens with these single parents? With married people, if something happens to one spouse, the children go to the other spouse. If something happens to both parties, then of course we have the issue of guardian. But we get this question a lot when we have single parents. So I'll have somebody come to me, a mom or a dad, and they may say, hey, if something happens to me, will my partner get or my child's other parent get the child? And the answer is probably yes. They would go to that parent first. But what if they're not there? What if they're not involved? What if you don't even know where that person is? Then you want to give some direction about who will take your child. But you need to make sure before you put somebody in there that you talk to them first. Don't let them find out at your death that you're asking them to be the guardian. That's a big role. And you want to make sure it's one they're ready to take on, because what you also don't want to happen is for you to pass and you have said, hey, I want Jammie to be the guardian. And Jammie says, I don't think so, because I don't have to do it. It's still my choice. So that's a conversation before we put it in your will that we encourage you or tell you that you need to have with whoever you're going to appoint as the guardian and the backup guardian before you put it in the will. In addition, sometimes people like to put married couples in there. That's fine. You can put a married couple in there. You can put your brother and your sister-in-law. But note that if your brother and your sister-in-law get divorced, then you have to decide what you want to see happen with that child at that point. Because you're saying, okay, I want my brother and my sister-in-law, but then what if they get divorced? Do you want the sister-in-law to keep the kids? Do you want the brother to keep kids? That answer might change. So be careful when you're putting two people as the backup guardians. But back to the question, anytime you have children, then you definitely need to have the will and put who the backup guardians are going to be, but also have that conversation with the guardians.
Yeah. And I find a lot of people, especially with younger children, they like to put their parents or their mothers as the guardian in case something happens. And I always have to advise, like, that's natural for us, right? It's natural for, especially, women or mothers, like, okay, I want my parents to take care of the kids, especially if there's a relationship there. But you have to think your parents are probably 20, 30, 40 years older than you. And you're like, because that's what it was for me for some years before I got married and had my other two kids. My daughter was to go to my parents. And then as my father started getting a little bit ill, I was kind of like, well, if my parents are together or they're both alive, then maybe it's okay for my kids to go there. But if one of them passes, that's going to be too much for, one of my parents. So that's the situation I'm in now. My father passed, and I was kind of like, when I was redoing everything, I love my mother, and that's who my kids have the closest relationship to. But I have to think my mother is 75.
Yeah.
If something were to happen to me. And so, definitely having those conversations with other people, making sure that they're, of age, maybe your age, maybe a little bit younger, that can take care of your kids. It's a huge responsibility. My kids, it's two of us. It's hard to keep them together. But I know.
You also might want to make sure they have sort of the same values that you have. So take that into consideration, because these are the people that are going to be raising your children. So that's something you definitely want to take into consideration when naming that guardian. Are the values, what type of life are they living now? Are they going to be able to provide for your children? Of course, you'll provide for them through your will and maybe your trust, where you may give a certain amount of money to be allocated to the children to help the guardian. But we all know that whatever you give, probably it might be enough, but there's always everything else. And you also don't want your your children to suffer because whoever you've given to them can't afford to take care of them, even though you're giving the money or they're using the money for something else. So just make sure that they have similar values, that you're sure that they can actually take care of your children without overburdening themselves.
And quite frankly, like I have different people that I think would be good to raise my kids if something were to happen to us, but then other people that would be good to control the money. And so
I never have those as the same two people if I can avoid it. And I tell my clients the same thing. Whoever the guardian is should not, if you can avoid it, be the same person as the trustee. I mean, the court's still sort of intervening in that situation, so there's some protection there. But generally, if you can name somebody else, then you should. It just makes for more honesty and a checks and balances. We always like checks and balances. So it keeps some checks and balances, making sure your children are protected. And quite frankly, also making sure the guardian is protected as well. So there aren't any claims that might come up later that they may have to defend. So if you can have two people, one is the guardian and one is the trustee, you should definitely do that. Of course, if you're parents, then you don't have that worry if you're naming your parents. But if you're naming your siblings, then you might want to name two different people.
Right. Something always comes up. We know it all the time. We have a few.
I'm good with kids doesn't mean I'm good with money.
Right. True. Very, very true. We have a couple questions that I want to get to. So one of the questions is, how often should the will be updated and or reviewed?
Well, we say anytime something happens, you should definitely review or update your will. So if you have a child, if you get married, if you get divorced, if somebody dies, then you should update your will. But just ideally, look at it every year, every couple years, just to see what it says and to update it. Like that, we try to send out something to our clients every year, just a friendly reminder to take a look at those documents. But any life-changing events, you should update it then.
Right. And so we have another question. How long does probate usually take for applying to be an administrator of an estate? So administrator or executor, depending on what you have going on.
Oh, Lord. So I just came back from the Fiduciary Law Institute, and we had this conversation because pre-COVID, it was pretty quick. I mean, in some counties, you could walk it through if it was uncontested. And by walk it through to everybody listening, that means the attorney would file the paperwork. We could literally go down there with the administrator or executor. They could take their oath and the court would give them their letters right then. Those days are gone. And how long it takes depends on the jurisdiction. It doesn't even depend on whether or not it's contested or uncontested. It just depends on the jurisdiction. At its height during COVID, courts were running like 6 to 8 months behind just on the filings, because you have to remember how the hospitals were taxed, so were the courts, because those people unfortunately were passing. And when they were passing, their estates had to go through probate. So the same way the hospital is now overtaxed and all these other companies, the court system was also overtaxed, and they're quite frankly still overtaxed. So I can't tell you how long it'll take. It'll take 6 months to a year at least, but it's a long process.
Right.
And that's another reason why you might consider doing a trust.
Right, because you're avoiding all of that.
And during that time, somebody's paying the mortgage if there's a house in place. There's a bank account that can't be accessed. Things are just going down the toilet while you're waiting for that, just for it to move through the process. And I'm talking about uncontested. We're not going to even get into contested, because that can be years and years. And now, people are doing jury trials for these cases. So you can go way down the rabbit hole if it's a contested, but on the uncontested, probably looking at about 6 months if you're lucky. It just depends, but it takes a good little while. With a trust, what would happen is, and we'll keep going back to the differences between a will and a trust as we go through this conversation. With a trust, what will happen is when the person passes, then the successor trustee would just take over and start paying bills, and they can access things just like that. So there's no process where they have to wait, notify heirs, go through the probate process. It just picks up seamlessly.
Right. So this is another good question, because I know there's two different lines of thought on this one, and the question is it beneficial to file a will in a county of residence? So I'm gonna let you answer that.
Okay. I see you're gonna make me go first and say what I said. I do not think that it is beneficial to file the will. And the reason I say that is because, well, I say it depends. Usually I say no. And the reason I usually say no is because if you move or if you change it, you might not remember that you filed it. And that could just cause problems. Now, we have had instances where we filed because we didn't know the person had a will, and then we found out after we filed that they did have one that they had filed. So I don't think it is, but sometimes I guess if you think somebody's going to come in your house and try to access it, then you can go ahead and file it. Or if you're older, then you might want to file it. But I don't generally advise my clients to file the will in the county where they live. I usually advise them to keep it in a safe place, like a safe deposit box, or a fireproof box in their home. But the issue with the safe deposit box is, of course, when you pass and the person has to have access to the safe deposit box, or we have to go through court to get access to the safe deposit box. Or if they don't have the key, which many people don't, then you have to drill to access the safe deposit box because they really doesn't have the key to the box. So you have to pay to drill. It's about $250 to drill that box open. So those are the issues with putting it in a safe deposit box. I haven't, despite my protest of people filing it, had any issue when people filed it. So I don't know why I still have that bias, but I haven't actually had any problems when they're filing it outside of us finding out once we've already filed the petition for administration. I just think that people move around so much and then they update their documents so much and they forget that they've done things, that's where the issue comes in, because people forget they filed it or they move and they do. I just think it's confusing. But what are your thoughts, Ms.
I get all of that. I do, but because I have so many situations where somebody is like, oh, somebody came in and they had someone so change it. And, now we can't find the original. This is not the way it's supposed to be. I'm more comfortable because I've had so many of those to say, okay, let's just go ahead and file. It's a very nominal fee to have it filed in your county and, know it's there. And then again, I think that, doing yearly checkups with your clients, just to remind them like, hey, has something changed? Is this still a good address? Are you still here? Kind of keeping it top of mind in case they do need to, file or update it or what have you. But I know, like I said, there's two schools of thought on that. But I think because I've had so many situations where I've had that and the drama and there's another will, we can't find it. Somebody stole it, like all of that.
Yes, like, we do have a lot of that.
Let's just, put it away. Or, I don't know. Yeah, I'm going with file it because of my experience. Because there's so much if it is in a safe deposit box. Some people are like, put it in a safe place in your home, but then the first person who gets to the house, they're the one that took it and they destroyed it because it didn't say what they wanted it to say. So yeah, it's very interesting. So whatever you're most comfortable with at the end of the day. Also, so is it beneficial to file a will with the county residents? Also, the healthcare directive with the health insurance provider. What do you say about that? I haven't come across that.
Me either. That's why the weird face. Okay. I guess usually when you go to the hospital, to the doctor, they ask you if you have one and you just have to do a copy. So that's probably why we haven't come across it as often, because a copy is sufficient. Whereas with the will, you need the original unless you jump through, so many hurdles to prove that you don't have the original. But with the Advance Directive, usually the copy is sufficient. So yes, you can file it with the healthcare provider. And usually when you go to the hospital, they ask you if you have one.
Yeah. Here's what I want to say, what I'm going to talk about, because I know we're going to run out of time. This is a very, very basic hour today. But just speaking of the healthcare directive, so many people, are working with, or they have elderly parents that are getting a little bit older. It's so important for me to tell my clients to just have a list of your medications. And I think that's something that people forget to do because, as you get older, you are on medication, blood pressure, diabetes, like whatever it is. And if something happens to them, or you have to go to the emergency room, you have to take your parents to the emergency room. One of the first things they're going to ask, they ask about healthcare directives, but they also ask what medications are you on? And so just have a list, just somewhere we have important papers of medications. If you have someone who's taking a lot of medications, because you don't want, whatever they have to do to interfere with what they already have in their system. And I have a form, on my website that just says medications list. You can download that and just write it down and just keep it with you with important papers.
That is excellent. I have not given that advice. I love that, though. I think that's great advice to give to your clients. I always tell them to keep a list of their accounts and life insurance policies, because there's no great life insurance database. But I'm going to add that. I like that, because they do need a list of medications. And you're so correct. They always ask that question. So it'll be helpful if you've already provided it for them.
Yeah. So something simple. So there's another question. What kind of assets cannot go into a trust?
Well, everything can actually go in the trust. The issue is whether or not you should put it in the trust. So there are certain things like your IRAs that you should not put into the trust, or is advised that you not put those in the trust. And the reason is because of the tax issue. Because many times when you're getting ready to do the transfer, they look at that as a withdrawal. And so you could have big tax penalties as a result of that. So it's not really what shouldn't go in there, because you still have access to it. It's more what shouldn't go in there because of tax consequences. Or sometimes, I guess, if you have like a named beneficiary, like your life insurance policies, money market accounts, anything where you have a named beneficiary, if you're fine with it just passing to that person, then you don't need to put that asset into the trust. Usually we're only putting life insurance in trust if we want it to be in the trust, because we want it to go other places. Otherwise, I don't typically put life insurance in there. I don't put anything typically where we have named beneficiaries into the trust.
So I want to touch on this really quick, and you can probably talk about your experience with it, but I want to always stress parents who have special needs children, or nieces or nephews or whomever, who may need care for the rest of their lives and are receiving benefits, and the importance really of if you're going to leave something to them in a will versus a trust, because you want to go.
Don't leave it to them in the will, because they're going to lose it. I mean, they could lose their benefits because of it. So special needs is a whole different ballgame, because we need to do a whole different type of trust. We're not doing our regular revocable trust. We need to do a special needs trust, because you don't want your the child or the adult or whomever you're leaving that to lose those benefits because of whatever you may be potentially leaving them. So that is a whole separate game, but don't leave it to them in the will. Don't do that.
Right.
But don't leave it to somebody else either, because when you leave it to somebody else, they don't have to give it to them. They don't have to use it for their benefit. So even on the life insurance policies and things we were talking about like that, don't leave that to somebody hoping that it'll get to whomever you want to give it to try to avoid the government. Just create the right tool, create a special needs trust, have somebody do that for you so that you can make sure those protections are in place, but you still want them to be able to benefit from it. So don't leave it in your will, and don't leave it just basically in a basic trust. You need to create a special type of trust for that.
Right. So I just kind of want to reiterate that it is important to have a special needs trust, and so your beneficiary does not lose benefits if they are receiving them federal funds or funds from somewhere.
Or if they could receive them.
Go ahead.
I said, or if they could receive them.
Right. So one question, this is going to be very, very basic, really, to a lot of people. The question is, why is probate needed in the first place? And I know that seems very elementary, right? Why is probate needed? Because what I have seen, and I've seen it personally, and I've seen it with clients, is that you have a family member, they pass, and somebody just starts paying the taxes for years and years and years and years. and another person passes. And then something happens. Let's say we'll go back to like Katrina, right? When we had the disasters with Katrina and we had, FEMA coming in and people were getting assistance, to rebuild and all that. And then a lot of people, especially African Americans, were denied funding or assistance because the property wasn't in their name. It was in their grandmother's name, their great grandmother's name, but they were paying taxes on it, houses paid for, but you live
living in it.
And then you're denied all of this. So, and I see that so much. Like, I get people who call someone passed 10 years ago, 15 years ago. What's the importance of probate?
Well, you're touching on that heir property issue where it passes. I get that a lot because I also go to a lot of smaller counties where mom or dad might own like 5, 6, 7 different properties. And like you said, mom or dad passes. Some kid moves into the property, they start paying the taxes. And then I'm sure you've seen like 6, 7 generations pass. And this property never got probated. So that property never changed names. Now we got to try to go through 6, 7 different probates to get that property to whomever it's supposed to go to. And now we got about 50 people we got to figure out. Right. I have something on my desk right now from the court where we named like 17 people and they want me to tell them the date each person died. We don't know.
Right. Right.
We didn't even know these people. They didn't even know who these people were. So the initial question was, why do we have to go through probate? And I'm going to tell you what my mom and daddy used to tell me, because they said so.
Because we said so.
We have to go through probate because the government has said we have to go through probate in order to get these property transferred into our name. So you have to do it because they said so. So when somebody passes, if the property is not titled in a way that will allow it to pass without going through probate, the only way to transfer title is to go through the probate process.
Yeah. And let's talk a little bit about the titling, because we touched on it briefly in, again, another group that we were in. Someone mentioned like how to avoid probate and all that. And it was kind of general. So some of it wasn't, didn't apply necessarily to our state, that kind of thing. But it's, avoiding probate if you have a home. Now, so I work, a lot. I've done probably close to 10,000 closings. So dealing with, the titling of property. And in Georgia, legal disclaimer, none of this is legal advice to anybody who's listening. Anything that we have said is not legal advice.
We're only talking about Georgia.
Only talking about Georgia right now. Even if you're married and you're both on the title, if it's not titled specifically as joint tenants with the right of survivorship, it's going to have to go through probate, even if, again, you're both on the title. And that's something that happened to my parents just recently. So my father, he passed beginning of last year. My mother was trying to refinance a couple of months ago. It didn't even occur to me to think about and look at their deed. She was trying to refinance, and then the title company was like, well, you don't have, like, where are you in probate and all that. You don't have title basically to do this. Robert Johnson is still on here, which is my father, because it wasn't with the joint tenants right of survivorship. They were just tenants in common. And I know all that terminology can be confusing. Maybe you can explain it.
That's very important. I call them probate hacks. That is one small probate hack that you can take to avoid probate, is to change that deed today from, most deeds don't say joint tenants with right of survivorship. At closings, they don't do it. It doesn't say that. It just has both parties' name, which is tenants in common. So unless your deed specifically has that JROS, joint tenants with right of survivorship language in there, then it will have to go through the probate process. So one of the probate hacks is to change that deed. It's real easy. It's a quick claim deed from you and your spouse to you and your spouse with joint tenants is right with the right of survivorship. And that way in Georgia, it passes by operation of law. So usually we do an affidavit of assent and file a death certificate with the real estate division, with the Superior Court to show that person has died and now the property belongs solely to you. Now, Tamika, I know in some cases, and you can correct me if I'm wrong, since you do the real estate as well, I know title companies still want us to do another deed, basically deeding the property from me to me, just for purposes of title. But it's a wonderful tool that people can use. Is really inexpensive. Most attorneys don't charge that much to do a deed, or, it's relative, don't charge that much to do a deed, transferring that property from you and your spouse, or you and whomever that other person is, to joint tenants with right of survivorship. It's just so easy, and something that everybody should do.
Right. And so
but don't add your children.
Okay.
Don't add your children. If you don't take anything away from this today, Jammie Taire says, do not add your children to your deeds, because they will turn on you. Even if you don't think that they will. And you will call me and you will say to me, Jammie, I want to refinance my property. And do you believe they won't let me? And then my child, it'll happen. You don't think it'll happen, but it'll happen. So don't put your children on your deeds. You can leave it to them through the will, through the trust, some other means, but don't put them on that deed. Plus, if they find themselves in a credit situation, then they can attach your property, because now they're on the deed. So I give that information for couples, not for children.
Right. Yeah, that's huge. So, and I've had experience, like, the kids will kind of be there. They don't know, and they'll go ahead and sign when it's the parents refinancing or something. But yeah, if you have somebody who's like, no, or, why, and they start thinking, well, my mother is getting dementia or something, so they don't need to do all this yet. So you definitely have to be careful of who you add on the title. But it is, super simple. And I, really want to tell that to married couples, especially because you don't know. I've gotten calls. It's like, I thought it was just going to come straight to me, and it doesn't. And then
you have to go through the whole probate process, which is time consuming and costly, just because of one property, which is terrible, because even when you go to an attorney, even at the most basic level, even if we're doing something small, it's probably going to cost you a few $1,000s, where that could have been avoided if it would have just said joint tenants with right of survivorship. Now that process, that property doesn't even have to deal with probate at all.
Right.
A lot of married couples, all their joint bank accounts are together, so that doesn't go through probate. So if you get that property out of there, you might have a situation where you don't have to do probate at all.
Yeah. And I know on the blog post that you did about Chadwick Boseman, you spoke about having a trust, and one of the benefits of having a trust, and it was for privacy. Mm-hmm. So just talk a little bit more about that, because you have not been through the probate process. You will get inundated with phone calls, letters, people driving by, because they know that someone has passed, and they will look you up quickly, because you have to disclose everything in a will and through probate. So I'm going to let you talk about that just a little bit.
That is correct. Because when you go through the probate process, anybody can go down to the probate court. And if you take a trip down there, you'll see some of those companies down there just reviewing the documents. Anybody can look at the will. They can look at the file. They know everything that you file. All of that is public information. It's not private. And people say, so you can just go down there and say the person's name and look at their file. That's how it works. And they don't even have to say the person's name, because when you go to probate court, there's a whole bunch of books down there. They can open up one of those books, and ta-da, there's that person's will and all the information related to their case. So if you're a private person, or you don't want everybody in your business, that's another reason why you want to go and do a trust, because the trust isn't filed in court.
Right. And especially if you have a significant amount of assets, you have to disclose what you have.
Yep.
And you can get that. And so people, they're online and they're looking what notices, maybe, that's what they look at. Like, what has been published in the paper?
Yeah.
Who's applying for?
I think they look at obituaries now.
Do that? Yeah, they probably. Yeah, they do. they start early. Yes, the ones who want to get a jump on it, they look at obituaries. The other ones go through the records online, and they can just look at that and see who's applying for who, for what, and for whose estate. So We have about 6 minutes left. Can you, in 6 minutes, just talk about briefly the probate process?
Okay. Yes. So I am going to talk about it. I'll try to talk about it both ways. First with a will and the second without a will. So if you have a will and someone has passed, and so you come to my office and say, hey, Jammie, I need to file something. I have this will. What do we do? Well, the first thing we do is we look to make sure the will is valid. And by valid, we mean just because there's a will doesn't mean that the court's going to accept it. It could still be deemed to be invalid. So the first thing we need to do is make sure that it's properly signed. In Georgia, you have to have 2 witnesses on the will. You don't have to have a notary. It just has to be witnessed by 2 people. So we check to make sure that's it. We next check to see if there's a self-proving affidavit. That's the additional sheet that is notarized. And that has the witnesses and a notary. And the reason that's important is because if we don't have that additional sheet, then we have to go and find your witnesses, which can slow down the process significantly. So let's just say it's a good will. We see the signatures are in place. It's notarized. So now we prepare the petition for you. After we prepare the petition, we send it off to you. You sign it. If there are heirs, by heirs, I mean children, spouse, whomever, not people who are in the will, the heirs, which are different. And then we also have to see if they will sign off on it, because that determines whether or not, in our minds, if it's contested or uncontested and how the process will work. So say, for instance, I'll just use my family as me and my husband and child, then we would have to give notice to, if my husband's filing it, to the child. If the child is under age 18, then a guardian ad litem has to be appointed. I think I'm making this more complicated. This just tells you how complicated it is. A guardian ad litem has to be appointed. In some states, like I know in Texas, because my dad passed not too long ago and he was in Texas. In Texas, you don't actually notify all of the heirs. You just notify all the beneficiaries, which is different. In Georgia, you notify all the heirs. The difference between those 2 things is heirs are people, how can I describe it, Tamika? It's our natural descendants, I guess, our line. So like your children, your spouse, that kind of thing. The beneficiaries are people who you want to give stuff to. So they aren't the same people. In Georgia right now, anyway, you don't have to notify heirs and beneficiaries, just heirs. Then we send a letter off to them. Hopefully they'll send it back with the acknowledgments. Then we file it with the court. After we file it with the court, if you ask for certain powers, then it's published in the paper once a week for 4 weeks. If nobody objects, then the letters will be issued to you. Once you're issued the letters, then it's published again in the paper once a week for 4 weeks for any creditors. So that notice is going out to any creditors to say, hey, this person has passed. If you want to file a claim against the estate, now's your time to do it. The creditor has 90 days from the time that that first notice runs to file a claim against the estate. Now, during this period of time, whoever has been named as the administrator or executor over the estate is busy about the business of what's called marshaling the assets. So during this time, you've opened up a bank account because you now have the documents that you need to do that. You've opened up a bank account in the name of the estate. You're checking to see, outside of the creditors, any bills that are coming in, because you watch the mail to see what bills are coming in. You're also checking to see what assets they may have. You're closing out bank accounts, putting that money into the estate account. So you're handling the business of the estate, mortgages, calling them, sending out notices to creditors. All of those things is what the administrator or executor is doing during this period of time. And you actually have 60 days and 6 months from the time that you're appointed as the executor or administrator in which to do this. So let's just say now that 90 days has ended and you're trying to figure out what you need to do. Well, now we got to figure out which bills need to be paid. There are certain bills that get paid first. So things like me, the attorney, paid, funeral costs get paid off the top. Any expenses that you may have incurred after you've gone over those with your attorney to make sure they're legitimate also are paid. So those things get paid off the top, and then we can start going through the creditors and seeing if there's money in the estate to pay those things. It's wrapping up, so I want to quickly. So after all those things are done and we made the disbursement to whoever the heirs or beneficiaries are, then we can start moving towards closing up the estate.
Okay. So, I mean, that's in a nutshell. And that's if there isn't anyone contesting it. Now, you have someone who contests it. The whole process is extended. It can
Yes.
be years, depending on what assets we're talking about. It happens all the time.
It does.
So many people think that, oh, my kids are fine. They all get along. I am telling you, Jammie is telling you as well. And you've probably seen it in your own families. When someone passes, people come out the woodwork. People
Even
may
if
not
there's
have
nothing in the estate.
Right, right. They want something. They want something, and they will go tooth and nail, and they will argue with you. They will yell at you. They will hang up on you. It sounds like I'm talking from personal experience. I am, but also for clients as well. So yeah, definitely, if you are watching this, you have seen this, there is no excuse to not get something simple as a will done. And it does not take very long. You can just get just a basic will. Even if you're just saying, I want everything to be split among this person, that person, you just want to have something in place. You can always go back and say, okay, I want the house to go to this person. I want the car to go to this person, but just do something today. Get your affairs in order. And most clients that I don't have one who has it, but once it's done, just that peace that they have, knowing that it's done. I know it's daunting to think about the fact that we may not be here. There are so many people who are here today or who are not here today that were here a couple years ago. A lot of us lost so many loved ones. So it's just important to have it. Everyone says, most people say, I know I need to do it. I know I need to do it, but they don't do it.
They don't do it.
There's no excuse. There's no reason. It's very, very simple. Trust might be a little more complicated. They are going to cost you a little bit more, but if nothing else, have something basic. We haven't talked about this, but another episode that we're going to have coming up, because I got a call about it today, was about Medicaid recovery, and all that, which is a huge topic in and of itself. We're going to have a session just dedicated on that. I had someone call this morning who said, her father passed a couple months ago, and she got that letter from Medicaid saying that they're trying to recover some his estate or some assets because he was in a nursing home.
Oh, okay.
There is a way to protect your assets and go to a nursing home, have Medicaid pay for it. We don't talk about it often, but there is a way, and people are strategically using it to their advantage. There are people who are millionaires, thousandaires. They know what things to do. They know where to put their assets, how to protect it, so they can be cared for in the life in a nursing home. Jammie, thank you so much for coming on. I know you're busy. You've got all these different roles. I'm just kind of like, I didn't even know if I could get you on. And I was like, can you come on? You were like, yeah. I was like, can you do any of these? Like, yeah, sure. What? And I was like, well, just pick a date. And I didn't hear anything. And I was like, let me just pick a date for Jammie, because she is magistrate judge. She's a city court judge, and she's got her practice, and she's got her kids, her husband, and all that. So thank you so much for taking time.
Thank you for having me.
And so if you want to visit Jammie, her website is on the bottom here. It's smithtaire.com. I am at johnsonlawpractice.com. I don't care who you go to, just go to someone. Absolutely. Thank you again, and we will see you next Tuesday.
Bye.